to the fourth case on this morning's docket, case number 116586, State of Kansas v. Robin Smith.
May it please this court, Sean Minahan for the state. I'd like to request 3 minutes rebuttal, please.
3 minutes is granted.
The defendant in this case was charged and pled to trafficking methamphetamine in a correctional facility in the Johnson County Jail. She agreed to plead to that charge in return for the state not adding charges to the case. After she pled, they did an analysis of her criminal history, and they took 3-person misdemeanors and aggregated them into 1-person felony to make her a criminal history D. On appeal, she is now arguing that one of the person misdemeanors from Missouri shouldn't have been scored a person misdemeanor. There's a couple statutes that deal with this issue. KSA 216810A talks about what the sentencing court should use to score criminal history, and it includes violations of municipal ordinances or county resolutions. D5 in that same statute also says that all person misdemeanors, Class A non-person misdemeanors, and a little bit later, all municipal ordinance and county resolutions violations. And then once you get into KSA 216811, it talks about out-of-state convictions. It doesn't talk about misdemeanors or felonies. It talks about scoring out-of-state convictions. The problem arises in 216811 E2B, where it doesn't give guidance on how to treat ordinances in out-of-state.
If it's not a crime, is it a conviction? Are you convicted of a civil wrong?
Well, I think in Missouri they call it a quasi-crime. But I think if you can send somebody to jail, that's probably a crime. Although I guess you could do a civil contempt, and put them in jail. But generally speaking, I think Lackey is maybe the one that talks about the procedures and beyond a reasonable doubt.
But we've been, like on juveniles, we've said a conviction is not an adjudication. And, indicated that a juvenile adjudication doesn't fit within the definition of a conviction, haven't we? I'm pretty sure we've said that on some statutes, and so if it doesn't include an adjudication, how can it include a finding that you violated a non-crime ordinance?
Well, I disagree that it's a non-crime ordinance, and Lackey talks about how the state of Missouri can say, well, we don't call it a misdemeanor here. Municipal courts or municipal ordinances aren't misdemeanors. But I think it's important to first note that do we care about the state law when we're talking about categorizing a city ordinance? Does it matter what the state says about it if the city ordinance is what we're analyzing?
Carry forward with that, because the problem I'm having with your argument is that Lake Lotawana doesn't designate this as a misdemeanor or a felony. It just sits there. But yet other parts of the municipal code of Lake Lotawana will designate certain things. So it seems like they picked and chose, and from your perspective, they chose wrong.
Yeah.
I mean, how do we put a label on this when the convicting jurisdiction didn't?
Yeah, and that's difficult. But we have some cases like Hernandez where you had a military conviction, and but it didn't talk about, and they talk about the intent of the legislature in that, and they kind of combined the ordinance type stuff into that, and then Vega Fuentes, where they aggregated the cases.
But my problem with that is I don't care about the case law. I'm just really focused on the statute.
Okay.
And our statute says you go to the convicting jurisdiction. And I did that. And I looked at that ordinance, and this particular offense that you want to score and the other one that you kind of use as a backup just sit there blank.
Right.
Even though the city did choose other ones. That seems like a pretty tough problem for you.
It is a tough problem. It's not a great, the wording of the statute isn't very good. You know, if I were to go back and word it for them, I would probably talk about, you know, the federal definition of a misdemeanor and felony. That way you cover a lot of things.
Well, we don't get to do that, so what's
Right.
your path to victory here?
Well, I think that you can read into 216811E that it covers ordinances as well. And then you don't even get to a misdemeanor issue. Because when you're looking at these, you're
You want
looking
us to
at,
add a word to a statute.
but you don't take statutes in isolation. You look at the statutes as a whole and say, look, 216810A says that you score municipal ordinances. 28610D5 says you score municipal ordinances. 6811E1 says that you score out-of-state convictions.
Does 21-6810 cover out-of-state convictions?
I think it covers everything. I think it's the general analysis of how you go about scoring convictions, and then there's a specific provision.
Yeah, 11 talks about out-of-state convictions.
Right. But I don't think 6810 is limited to in-state. But when you take those all together, it's clear that the legislature intended for ordinances to be scored. And if that's the case, then you don't even have to get to whether this is a misdemeanor or not.
All ordinances, in other words, if you have an ordinance that prohibits letting your grass grow too long.
No, Your
Yeah.
Honor, because when... Can I get a water? Because when you look at these, when you analyze them, you have to determine whether it's comparable to a misdemeanor or B misdemeanor. If it's not, then you don't score it that way. If it's something less, if it's a C misdemeanor in Kansas, then it's an unscored misdemeanor. One concern that I do have is, we really don't have in the United States a model penal code that everybody started off with and used throughout this. And so there are jurisdictions like the military that don't don't use the term misdemeanor and felony. There are even states that don't use those terms. So an analysis that limits it to just the word misdemeanor and felony means that, certain states in the United States and the military no longer are scored because they don't say felony or misdemeanor. And I don't think that was the intent of the legislature to say that we don't like those jurisdictions that don't score them as misdemeanor and felony, so therefore the rape conviction from Maine isn't going to be a personal felony, and the murder conviction from New Jersey isn't going to be a personal felony because they don't score. They don't have felonies and misdemeanors in those states. I don't think I have anything. Oh, and finally, all of these cases, Hernandez, Vegas Fuentes, State versus Lackey, talk about it, using this ordinance language, looking at these as a whole and construing this to mean that it applies to ordinances as well. And these cases have been on, 20 plus years for Hernandez and Vegas Fuentes. And Lackey has been a law for 8 years now. And if the legislature didn't agree with Lackey or Hernandez or Vegas Fuentes, they had the ability to come back and say, no, that's not what we meant by this. But they haven't done that for 8 years. And that's what, prosecutors and defense attorneys have relied on since then. So, unless this court has any other questions.
Any more questions? Thank you, counsel.
May it please the court. Sam Shire appearing on behalf of Ms. Smith. This is a case that I believe the Court of Appeals decided correctly. And in explaining why that's the case, I think it's important to look at what the KSGA does and does not say about scoring municipal ordinances. So the starting point there, I think, would be KSA 216810A, which categorizes municipal violations as one possible kind of prior conviction. So that indicates that municipal ordinances can sometimes be scored as prior convictions in an offender's criminal history.
And you think that applies to out-of-state convictions for municipal ordinances?
I don't think specifically that subsection would, because that subsection is just breaking down the different kinds, the different categories.
You started your argument saying we start by looking at 6810.
Yes.
Does that mean that you think 6810 has some relevance to out-of-state convictions for municipal ordinances?
I think it indicates that some out-of-state municipal ordinances may be scored as person misdemeanor.
As opposed to 6810 is limited exclusively to in-state convictions and it doesn't cover out-of-state convictions, because we look to 6811 for that.
I think 6811 is the more specific statute. But I think the only thing that subsection 10 is doing is breaking down the categories. So that lets us know that one of the possible categories is municipal violations. And then we go on and look at KSA 216811E, and I believe that's the next step of the analysis, is looking at whether that particular statute lets us score an out-of-state municipal ordinance in an offender's criminal history. So that's the next step in the analysis, is KSA 216811E. And I think what's particularly notable there, and before I go forward, I want to emphasize that this court is interpreting the version of that statute which existed back, I believe, in 2016. It has since been amended. But what I think is significant about that 2016 version of the statute is subsection E2, which says that an out-of-state crime will be classified as a felony or a misdemeanor according to the convicting jurisdiction. And what's significant there, I think, is the word crime, because the only thing that this statute allows a sentencing court to do is to classify criminal convictions as misdemeanors or felonies. And in Missouri, Missouri law is not at all ambiguous on this point. Missouri municipal violation is not a criminal offense. It is a civil wrong. So because we aren't dealing with an actual criminal conviction in this case, I don't think that there's any mechanism in the KSGA that lets a district court decide that it's either a misdemeanor or a felony. And in this regard, I think that we're actually one step beyond State versus Horselooking, which is a published Court of Appeals opinion that the panel in this case relied upon. In Horselooking, this court was considering a tribal conviction, which tribal criminal code was simply silent on as to whether it was a felony or a misdemeanor offense. In this case, we have a non-criminal conviction, which according to Missouri law is neither a misdemeanor nor a felony. And Kansas case law, particularly at the time back in 2016, or pardon me, Kansas statute back in 2016 was very explicitly clear that the convicting jurisdiction is the entity that decides whether a prior conviction is a felony or a misdemeanor. And in this case, Missouri has said that their municipal violations are neither of those two. So I just don't see any opening in the KSGA for a district court to have scored these non-criminal convictions as misdemeanors. And one point that I would like to make in closing is that I don't think that this is all an unreasonable interpretation of statute, because if anything, I think it would be odd to say that a finding that you have committed a non-crime can elevate your criminal history score. That just seems to me an intuitively odd result. So I don't even think that we're necessarily dealing with a problem here where we have a result that's probably not what the legislature intended to be. I think that the legislature, when it enacted subsection E of 21 KSA 6811, was very clearly presuming that we were dealing with criminal convictions. That's why they used the word crime. An out-of-state crime may be classified. No mention of all as to non-crimes would tend to indicate to me that non-crimes are not intended to be classified. So for that reason, I believe that the Court of Appeals was correct in holding that Ms. Smith's Missouri municipal violations could not be used to elevate her criminal history score. So
Go ahead.
I was just going to conclude, Your Honor. I would respectfully ask this court to affirm the Court of Appeals.
It's your position that if you don't have a crime, you do not have a conviction?
I'm not entirely sure that's what my position would be, because I think the KSGA gets to decide what a conviction means within the meaning of the KSGA. But what we have here is a provision within the KSGA that says that crimes may be classified as misdemeanors. So if the legislature had said that non-criminal municipal violations may be scored as misdemeanors, then that's a different issue before this court. I assume that would be permissible, but I don't think that that's the situation we have here.
Perhaps what threw me off is I understood you to characterize what happened in Missouri as simply a civil wrong. Did I misunderstand you?
No, that's correct. That's how Missouri.
I'm sorry, go ahead.
That's how Missouri treats municipal violations as civil wrongs.
And can you be, quote, convicted, unquote, of a civil wrong?
I believe sometimes Missouri courts use the word conviction, but they're very clear that it's not a criminal conviction.
And that's why you would focus on the word crime in 6811E2?
That's why I would focus on the word crime, Your Honor.
All right, thank you. Any further questions? Thank you, counsel.
Just a couple notes. In Lackey, the court said, on the one hand, Missouri courts acknowledge that prosecution of a municipal ordinance violation is criminal to the extent that the parties are bound by the criminal rules of procedure. The prosecutor must establish the alleged violation beyond a reasonable doubt, and the defendant may be incarcerated as punishment if convicted. You know, it seems like, you know, if it walks like a duck and it talks like a duck, it's a duck.
What do they mean when they say it's a civil wrong only then?
I have no idea. You know, you can call, I suppose, it whatever you want. But if you have you have elements of the offense, you have a conviction, you are punishing a person by putting them in jail. That's a crime that is committed and punished. And as to the civil contempt, I think I want to clarify that a little bit.
Civil wrong?
No, civil contempt case that I said that you could go to jail. I believe, and it's been a while, I believe in civil contempt cases, you're put in jail because you're unwilling to do something.
Till you purge.
Yeah. Versus a criminal contempt where you're punished.
You hold the keys.
Yeah. And so there is even though you can in that civil context be put in jail, it's not for punishment
Counsel,
like it is here.
what's Missouri's sentencing scheme? Do they have something comparable to guidelines?
No, they have, it's
Okay.
like indeterminate.
Just classes?
Yeah.
Okay.
Yeah.
I was just gonna ask how they would treat this, if they would count them. But if they don't have a guidelines system, then maybe it doesn't.
Yeah, they probably would just.
Okay, thanks.
Any-
Yeah, the Court of Appeals relied on the rule of lenity.
Mm-hmm.
Earlier you said, well, we could just read into the statute something. How does that
Well, I'm.
factor into the rule of lenity?
If I said it that way, that's a little bit loose. I think that you look at these statutes as a whole. You don't isolate one statute and do another. And when there's an ambiguity like that, you say what was the intent of the legislature, and it's clearly the intent of the legislature to score ordinances and county resolutions. And so, and that's what kind of they read in Hernandez and Vega Fuentes, that kind of language into those. Unless this court.
Any more questions? Thank you, counsel. We thank both counsel for your arguments this morning. Court will take this matter under advisement.